piece of equipment that didn't allow me to do that. And so hopefully by next week, I will have bought a new one and can start doing that.
Ask a
At
quick
any
question.
time, what, Chinga?
Can I ask a quick question?
Yeah, yeah.
So you named all this. You named all the subcategories. Does cultural heritage labels have any standing in U.S. law, or even like respect for the international law of cultural heritage labels?
Yes, for in trademark law, they uh, yes, that comes in trademark law.
Thank you.
Sure. So for example, like use the name of a tribe to do something or things like that. Yeah, that is a subject in trademark law, which is the last topic we will discuss in this series.
Are we allowed to ask questions now, or should we wait, Sam, for you?
I would love it if you all ask questions as soon as it popped into your head, so it is not a monologue by me, and it gets broken up, and that way people don't get bored. So yes, please ask questions whenever you want, however you want. Go ahead,
What
Steve.
what what is the difference between a patent and a trademark?
Aha. So a patent protects the ideas. So the patent would protect the design of the product, the functionality of the product. A trademark denotes the source of the product. Where is it coming from? Who is making it? Yeah. So when you see a T-shirt with a Coca-Cola logo on it, you know that that T-shirt is connected. The source of that T-shirt is the Coca-Cola company.
And if I
Coca
could ask a follow-up, which I believe is on point, let's use a specific example. It's the one that always comes to my mind. Michael Buffer, let's get ready to rumble. Can you talk about that? Thank you.
Yeah, so that is a service mark, which is protected under the trademark laws. It's a slogan, and slogans are mainly protected by trademarks or service marks. I mean, service mark, trademark, trade dress, they're basically the same thing, exact same laws, but they apply to different things. This is not the name of the business, it's a slogan for the business, so it becomes a service mark. So that is protectable under trademark laws and potentially protectable under copyright laws because it's a written statement.
Thank you. Thank you.
Sure. So if there are no more questions, we'll start the slides. Or the link to the slides is posted to the top, and there should be like 16 slides total. So first slide is just the cover slide. Second one, we talked about the types of IP, trade secrets, patents, copyrights, and trademarks. These are the four areas of intellectual property law, and I have said what they protect. Trade secrets protect commercially advantageous information. So that's highlighted because we're going to talk about trade secrets. So slide 3. So sorry, I still have the University of Utah logo on these slides. For some reason, I couldn't access the master slide to remove that. Uh, so anyway, so trade secrets are the simplest form of IP, and it's because you really don't have to do anything in order to have a trade secret and protect the trade secret. And when I say you don't have to do anything, means that you don't have to register that with a government agency, or you don't have to basically announce to others that you have a trade secret. What happens with trade secrets is that you have your trade secret, you keep it a secret. If somebody violates that, then you go to court. and all the legal questions and determinations and everything happened during that litigation, which we will talk about at the end of the lecture today, or if there's no time at the beginning, tomorrow. So basically, the simplest form of IP is that you have a secret and you keep it a secret. And notice that I didn't say you have a trade secret and keep it a secret, because the determination of whether a piece of information is a trade secret or not, that is not a factual determination. That's a legal conclusion, meaning that you take all the facts into account and then you legally conclude whether the information was a trade secret or not a trade secret, and whether that trade secret was misappropriated or not. So unless and until you have a court decision that says this is a trade secret, whether or not you have a trade secret is up for grabs. So on next slide, I'm going to kind of shift focus a little bit and talk about the restatement of torts, and it becomes clear why I'm doing that. So what are the restatement of the law in the United States? These are a series of treatises that the American Law Institute and the Commission on Restatements, or part of the American Law Institute, they write these books and they summarize what common law in the United States means. So a lot of the laws that we deal with are statutory laws, meaning that the legislature of the state or Congress and the federal government, they have passed a law, a statute, and based on that, you behave. So like speed limit or murder or theft, things like that. But there are a lot of things that happen in the United States for which we don't have a statute. And these are decided by judges on a case-by-case basis. This type of decision making is called common law as opposed to statutory law. And we inherit this from the English, because the English were the first to come up with common law. And today, all the former British subjects or members or current members of Commonwealth, they all use British common law as the basis for their law. So torts is one of those things. We don't have many actual statutes on torts. Instead, torts are decided based on common law. So how do judges and lawyers know what the state of the law today is? Instead of everybody doing their own research and come up with their own conclusions, American Law Institute does the research and then publishes these restatements, and they tell you what the law is, what the common law is, and this has really the force of law. That is, courts cite to restatements in order to make decisions, and so they basically, what restatement says is the law of the land. I have put in the areas where we have the restatements. The first restatements appeared in the 1920s. They were only on the four areas of contracts, property, torts, and conflicts of laws, but then others have been added, liability insurance and employment law. Steve, you probably have seen the restatement of employment law. Though those are pretty new. I think 2015 or so they came up. So restatement on the next slide, slide 5, tells us a tort is a civil wrong other than in contracts that causes harm. So every time I do something and it causes harm and it's civil, so it's not a criminal wrong. It's a civil. Every time you do something and you suffer harm, and it's not a breach of contract, then I have committed a tort. And it has 5 elements: duty, breach, harm, causation, and damages. You have to prove all of these in the court in order to show that a tort has been committed. So we go to the next slide, an example. So I loan you my bike with the explicit promise that you will bring the bike back to me that afternoon. Why? Because I need the bike the next day to go to work. So this transaction has created a duty for you, and that duty is to return the bike on time. You return the bike 2 days later, so you have breached your duty. So far we have duty and breach. And then we have to have harm. And the harm is that I couldn't get to work on time and my boss yelled at me. And causation, that is, I was not on time because I didn't have the bike, and I didn't have the bike because you didn't return it on time. So we have established that your breach of your duty is the direct and proximate cause of my harm. And then there are damages. So I will not get a good year-end bonus because of my tardiness. So if I don't have any of these, so let's say you borrowed my bike and you brought it back late and I fell on my driveway and broke my leg, well, that harm was not caused by the breach of your duty. So that's not a tort. The duty, breach, and harm they all have to be proximately related to each other. Why are we talking about all these things? It's because trade secrets have historically been considered a tort. We have arrived at trade secret law through 2 different avenues, 2 different torts. One is the tort of misappropriation, which is now a part of statutory trade secret law, and the other tort of unfair competition, which is still a tort, even though we do have statutes on that. So before any statutes were established for trade secrets, all of this analysis was done using torts. But the restatement of torts, restatement third, which was published in the 1980s, removed, 1990s, that removed trade secret as part of the tort of misappropriation and unfair competition. This fact becomes very important when I discuss the case at the end of this talk. So it is not a tort. It is not a common law thing. So what is it? Today, it is a statutory cause of action, trade secret laws. That is the Commission on Uniform Laws, which is a commission of lawyers and stuff. They come up with uniform laws for all states. And these are normally in the areas that are really important for the economy and trade and commerce, etc. Because what you want to have is you want to have uniform laws across all the 50 states. So within the United States, you don't have legal issues, legal discrepancies from one jurisdiction to the other. When the laws are all the same and you comply with one, you've complied with all. That makes commerce a lot more efficient. So 48 states have enacted UTSA, the Uniform Trade Secrets Act. New York introduced it, but didn't pass it, and they still rely on common law. North Carolina changed it a little bit, and the Uniform Law Commission said that's no good. You're outside of what we were thinking about, so they didn't confirm it. But Alabama tweaked it, and they said, yeah, that's okay. In Utah, where I am, the UTSA exactly as submitted by the Uniform Laws Commission was enacted as Title 13, Chapter 24. So what does this say? Now let's talk about some laws. What is a trade secret? A trade secret means information, including blah 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 blah, that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use, and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So what does that all say? On slide 10, I have distilled it to its important points. So we have, there are three elements to what a trade secret is. First of all, you have to draw independent economic value from the fact that this information is a secret. So the code that I use to run my computer could be a trade secret because I derive independent economic value. But if I keep the fact that my dog poops 3 times a day a secret, that is not a trade secret because I don't derive any economic value from the fact that my dog poops 3 times a day. So it has to have that independent economic value, and it should not be generally known or readily ascertainable. Where generally known, we know, right? If it's generally known, then it's not a secret. If it's not a secret, it can be a trade secret. Where readily ascertainable, what does that mean? What does readily ascertainable means? If I ask you guys what readily ascertainable means, you all will say, well, it's something that you can figure it out really quickly. Well, but what does that mean in reality? I'll leave that question hanging. And then it should not be readily ascertainable by proper means. And it needs to be subject to reasonable efforts to maintain its secrecy. So if I leave the code for my computer, for the software that I use in my business, if I put it on flash drives and leave it around in Starbucks or whatever, then those are not reasonable efforts to maintain its secrecy. Clearly not. I'm not doing anything to maintain its secrecy. So it has to be subject to that. Now, why do we require reasonable efforts to maintain its secrecy? It's because the owner of the trade secret is going to the court and asks the court, help me. Somebody stole my trade secret. Do your justice. And the court says, well, what did you do? What efforts did you do? Now that you're asking me to put all this effort to help you, did you yourself put any efforts to help yourself? And if you haven't, then the court says, well, don't expect help from me. If you weren't willing to do the work yourself, then you can't expect me to do the work either. So those terms that I've highlighted in red, readily ascertainable, proper means, reasonable efforts You have to be a lawyer to know that those terms are vague. They are not well defined, and they are subject to argument and disagreement. And so when you look at all the trade secret court cases, you see that the fight was always over these. Was the information readily ascertainable? What does ready ascertainability mean in law? How readily should something be ascertainable before we say it is readily ascertainable? What are the proper means? The what I did was not illegal. So so was it improper means? You have to the court has to decide that. And what are reasonable efforts, right? Not all efforts are reasonable efforts. So did you do enough, basically? And so we can see that the these questions end up being where the litigants fight over. One says, yes, my efforts were reasonable. The other one says, no, your efforts were not reasonable. And so the court uh, gets in. On slide 11, we talk about other provisions of the code of the Uniform Trade Secrets Act. The first one is misappropriation. This really is a restatement of what the tort of misappropriation was. It's just that now it's a statute passed by the legislature. So acquisition of a trade secret of another by a person who knows or has reason to know that the trade secret was acquired by improper means. So you know or you have reason to know. And we'll talk about what that means if you have reason to know. Disclosure or use of a trade secret of another without express or implied consent by a person who used improper means to acquire it, or at the time of disclosure had reason to know, knew or had reason to know that his knowledge of the trade secret was derived through improper means or by someone who themselves obtained it by improper means. So what does that mean? It means that if I'm talking to my neighbor and says, oh yeah, you know, we just started a new startup company, it's great. Here, let me show you our business plan. At that point, someone like me would say, no, a business plan for a startup company is the most valuable trade secret that they have. That is, no company will publicly discuss their internal business plan. So if somebody's going to discuss their internal business plan with me, I know or should know based on my experience that this is a trade secret, and its disclosure to me is going to be improper because I don't have a non-disclosure agreement signed with the company. And so I'm on the hook for misappropriating the trade secret because I acquired it while knowing or have reason to know that the trade secret was acquired by improper means.
Sam,
Yes.
specific example. Hopefully, it's on point to what you were just talking about. Both Windows and Apple came out with their home computers originally, which most represent what we have today, back in 1986. Bill Gates worked for Apple for a year and a half, 2 years, when Apple was working on their graphic interface. I don't believe there's ever been a graphic interface prior to 1986. Bill Gates left and then arguably incorporated that graphic interface to Microsoft and called it Windows. Is there any I don't know what you want to call it, but trade secret violation, any type of violation that Bill Gates arguably stole Apple's idea?
So I don't have enough facts to determine that because uh, I don't know exactly what information Bill Gates took and how much of that information would have been readily ascertainable by the fact that Apple's product was out on the market back in the mid 80s. Was the security on the software strong enough that nobody could hack it? If they could hack it, then it was not subject to reasonable efforts, right? So I need to know those things. But the case that you're specifically talking about rested mainly on copyright violations as opposed to trade secret violations because of the format of the windows that it looked exactly like drop-down windows of Apple.
Thank you, Sam.
Sure. So those were misappropriation and improper means. What are improper means? Well, the statute gives some examples: theft, bribery, misrepresentation, breach or inducement of a breach of a duty, espionage through electronic or other means. So you see that what the statute puts up there is not something that you sit there and debate. Is this proper means? Is this improper means? What's going on? But well, how about dumpster diving, right? If you throw your trash out and then at night I rummage through your trash, is that improper means or not? Well, that depends on the facts. If you had a lock on the trash bin, you didn't. So you go you see a lot of these big trash bins. They have a bar. The ones that are in the parking lots of office buildings, they have a bar and a lock on it. Some of that is for safety reasons, so nobody gets in, but a lot of that is to prevent dumpster diving. Meaning what? Meaning you extend the reasonable efforts to protect the secrecy of your information all the way out to the parking lot and the trash can. But there are some proper means, right? You can independently discover the trade secret. There's no bar against that. We see that you can't do that with patents or copyrights. Once you invent something, you've invent something and patent it, then no one else can independently do that and use it. They would run afoul of your patent. But trade secrets, if you independently discover it, that it's not subject to misappropriation. You just did it without any knowledge of the secret, so that's okay. Reverse engineering is also is also a proper means, and it's one of the biggest proper means that we have. So you basically, product goes on the market, you analyze that product to death to figure out how it was made, how it works, and then you copy that. This is perfectly okay if there are no patents or other forms of IP protecting it, if it's only a trade secret. So what do we have is, for those of you who've worked in big companies with big coffee machines, what happens if something's wrong with a coffee machine? You can't open that. If you open the coffee machine, all warranties are lost, and you're basically out on your own, and that's a huge harm to the user. So what do you have to do? Anything that goes wrong, you have to call the dealership and they send a certified service person. They open the machine. Why? Because inside of the coffee machine is all trade secrets. And this is part of the reasonable efforts to protect the trade secrets inside of the coffee machine. Same thing with your laptop. If you open up your laptop yourself, if it's not an authorized person, then you basically lose all protections, all warranties, all everything. This is another way of protecting the trade secrets. What was another way of reverse engineering? You have the software, you hack into the source code, and you copy the source code. That's reverse engineering in a way. So what do companies do now? Nobody sells you software anymore. It's all web-based, and you buy a subscription to it. So, and that's again part of the proper means, part of the reasonable efforts to protect the trade secret. So we saw that trade secrets at the beginning, we said it was a tort. It was treated as a tort, but then the courts moved away from that and took up the statutory version of it, to the point that Restatement Third basically came out and said, this is no longer a tort, so don't treat it as a tort. New York didn't like that, but everybody else is doing that. So why is it that the courts and the law is moving away from the restatement definition of a trade secret? And in the case of Inosis v. Mercer, which is v. Lurd, it's a Utah Supreme Court case, 2015. I'll talk about it a little more. The court says this, that trade secret is a property right, and in the United States, there's a legal presumption of harm when property rights are violated. So, for example, somebody can trespass on your land, meaning that every morning that they're going to walk to the bus stop, they go across a corner of your yard in order to get to the bus stop. They are trespassing, right? We don't then ask if this person who's trespassing is causing harm to the grass, to the land, to the owner, etc. We don't ask that question. We presume that harm is being done. The amount of harm that's being done goes into the determination of damages. So, do you get a damages of $1, or do you, or were there actually greater damages that now you have to calculate and pay for? So presumption of harm is always there for property rights, violation of property rights, and the court says this presumption flows from the very nature of a property right, which at its core is a right to exclude others, right? We talked about it last week, that property rights are exclusive rights, meaning that the only thing you can do absolutely when you have a property right is exclude others from the use of that property. And so if we allow somebody else to use that property by trespassing, then necessarily we have caused harm to the property owner. So why is this important? It's because when we discuss the elements of tort, what were they? They were duty, breach, harm, causation, damages. If you don't have harm, you don't have a tort. But you could have a trade secret misappropriation without actual harm, and that would still be harmful for you. This is what the court is saying here, that we're moving away from torts because we're saying that we don't have to prove harm. We can just assume or presume harm, and if we're doing that, then we're outside of restatement and outside of torts, and we're into statutory law. Before I go into the details of Inosis, are there any questions? Let me. So I'm looking at the room chat comments. Yes, you can. You in the United States, you could have trade secret vis-a-vis the government. The government uh, doesn't have margin rights on trade secrets. The government has once if a government agency has funded your project. For example, you have an NSF grant or an NIH grant or an NEA grant, National Endowment for the Arts, and then the result of that is going to be a patent or a copyright or whatever. The government, because they provided the funds, they have a march-in rights, meaning that the government can march in and take over the property right or use it for the public good without paying you royalties. This has never been used in the United States. When the attacks after September 11th, when we had what was that bacteria that they sent through mail? God, I forget it. But Cipro was the antibiotic for it. And Tommy Thompson, who was Secretary of Health and Human Services at the time, thought about canceling all the patents to Cipro. But there was such a huge backlash from everyone that he quickly withdrew that proposal. And that's, as far as I know, that's the closest we came to the government exercising margin rights on intellectual property. So yeah, we do have IP rights vis-a-vis the government in all areas. We will talk about this hopefully when we get to patents, in terms of if the government itself can infringe or not under the principles of sovereign immunity and 10th Amendment and 11th Amendment and things like that, but that's not something we're going to discuss now. Any other questions? Okay, so let's talk about Inosis v. Laird. I just want to say nobody knows who Laird is. Laird probably was a litigant who dropped off at some point. And even when you look at the decision says Inosis v. Mercer, but the reporters all write it Inosis v. Laird. So I don't know why. So what happens? Inosis is a Utah company. It's a tech company, and they hired Mercer right after she graduated from the University of Utah School of Engineering. She was an engineer. After a while, things didn't go well, and so she was fired. When she was fired, she filed a claim for unemployment benefits with the Department of Workforce Services, and that claim was denied. And so she reapplied, and as part of the reapplication, she provided certain documents that belong to Inosis and submitted those in her file. And so those files are public. or at least more public than Inesis wants them to be. In fact, so even if they're not public, this is a disclosure to a third party of Inesis's information. So Inesis went and said, "What the hell?" And she said, "Oh, I had permission from the IT department." So what she'd done is that she had a whole bunch of important documents. She had emailed them to her Gmail account. She had the company's business plan on a thumb drive, and the presence of these documents at her home was against the company policy that she was aware of or should have been aware of, because it was brought to her attention once she was hired as part of the non-disclosure agreement, the NDA, that she had signed. These provisions were in there. So Inesis asked, "Well, how come you emailed these? Who told you you can do that?" And she said, "The IT department gave me permission." So the chief of IT said, "Well, she just asked me, can I email a document from my email to my Gmail address?" And I'm like, "Yeah, you can do that." I didn't know what the document was. She didn't ask me about the trade secret nature. She just asked me whether emailing a document is possible. I took that as a technical question, and I said, "Yep, it's possible. You can do that." But so it was not a legal permission. Next one, and then when she was terminated, again the NDA said that she would be returning all information that she had to Inesis, and she didn't do that. Why is it that she didn't do that? And she said, "Oh, the company had asked me to work on the business plan, so I took it home on the weekend to work on it, came back on Monday, and I was fired." And so everybody kind of raised their eyebrows that my guess is that on Friday they knew they're going to fire you, so they're not going to ask you to work on the business plan at home over the weekend. And so those didn't go anywhere. So what she did is the thing that nobody in the world should ever do. She asked her lawyer sister for legal advice. What you never ever do is you do not ask a family member or a close friend who's a lawyer for legal advice. That is something you never ever do. The same way that doctors don't operate on their family members or treat their family members. There is so much conflict of interest that I mean, I'm surprised the bar didn't go after the sister for having done this. So especially since, based on the advice of this lawyer sister, she deleted all emails and files that had any information on Inesis, and sent an email to Inesis that, "Hey, I did this." This is the other thing you should never ever do. As soon as you find yourself in a adversarial position, if you delete any information, that's called spoliation. You spoliate the evidence, meaning that you have destroyed crucial evidence. As soon as you find yourself in a hint of an adversarial position, you need to retain all records. We had this conversation at one of Dr. James's rooms, where the court had told OpenAI that they need to retain all records, and that's because the court determined that OpenAI right now is in an adversarial situation and is potentially looking at several lawsuits. And so the court told them that you are in an adversarial position. This was something that the court is saying, I'm not going to leave you to your own interpretation of the situation you're in. You are in an adversarial position, so retain all your records. And so Mercer, by virtue of the conversations she had had with Inesis, should have known that that she was in an adversarial position and shouldn't have deleted anything. So what happened in this case? What happened was that the trial court decided that, oh, trade secrets is a tort. The trial court forgot that Utah had passed the Uniform Trade Secrets Act and basically said that Inesis, the company, hasn't shown any evidence of actual harm by Mercer stealing these documents and giving them to DWS. Utah Supreme Court here says not so fast. And that is the passage that I put down a couple of slides ago. That was the reason that you cannot ask the plaintiff to give evidence of actual harm because trade secrets is not a tort. It's a property right. And so a violation of a property right is necessarily an irreparable harm. And because we're not doing the harm analysis, then we can't do this in torts. We have to do it under UTSA. And under UTSA, basically the taking of the information home, that was misappropriation. The disclosure of the information to DWS was also misappropriation. So she was on the hook for misappropriation of trade secrets. So as you can see, this case, has a lot of other branches. Also, there's breach of contracts for the breach of the NDA. There was wrongful termination on the part of Mercer. It was a very complex case when it was first filed, but the Supreme Court case, the Utah Supreme Court case, basically in this instance just dealt with the trade secret. So Inesis in Utah is an important case because it is a case that tells all the courts and all the lawyers from now on, you have to use UTSA in Utah. You can't use torts. And also it's important because it kind of goes through and describes the elements of trade secrets really well. Well, this concludes the formal talk that I have prepared for today. And I look forward to the discussion that will surely ensue. Please raise your hands if you want to come up. Oh, Shamash, I forgot to mod you up.
Yeah, thank you. And that was a nice idea for the series. This is quite interesting, actually. I do have a small question, maybe. So, if let's say I'm cooking chicken, right? I'm frying chicken and I'm putting some trade secret spice sauce, all right? And I haven't patented. But then this employee of mine leaks it to a competitor, and then the competitor claims that, oh, we just found it by accident. It's just a combination of spices. It's fair to assume that someone would figure it out on their own. Is there a court case that I can make that there was a breach of my trade secret here, or is it my responsibility to force my employees to sign NDAs or whatever, even though I haven't patented the recipe?
So, first of all, an NDA needs to be a part of the employee handbook. So the employee handbook has to have, besides that, this is your dress code, you show up on time, your vacations, this is your insurance. It has things that says, whatever you do here is owned by the company, is the IP of the company. You have no rights to it. You have to assign it. And another section of it is an NDA. All employee handbooks, if they're well written, include the NDA, and that NDA is also a lot more robust and complicated than the NDA that we generally use, because they have provisions in there that are specific for that business. So in some states, the law, the employment law or business code, things like that, they basically imply an NDA in the condition of employment. So basically, by statute, the state says that if you work here, you're subject to these NDA provisions. The same way that by statute, for example, in California, Business and Professional Code 16600 says that you use your master's equipment, time, money to come up with something the master owns. And so assignment of inventions becomes a duty on the employees by the operation of statute, even though your employment agreement by contract says that you have a duty to assign your inventions to the employer. So this your employee is already under some form of NDA, but let's say is not. Let's say you see that the statutes that we put up there for trade secrets, for misappropriations, none of them discuss the presence of an NDA. None of them discuss the presence of a contractual obligation to keep the information a secret. They all said this type of information is a trade secret. You do this with it, you've misappropriated it. And so we then can, regardless of whether an NDA exists or not, we can go look at your employee and say, what was the information they stole? Are you gaining independent economic value from it? Was it subject to reasonable efforts to maintain its secrecy? Did the employee take it by improper means? And then if all of those conditions are met, you have a trade secret, and then you look at the statute and say, did the actions of the employee amount to misappropriation, and then you make your legal conclusion. Did that make sense?
Clear. Thank you.
Sure. Yeah, sorry, the last three comments, I'm not really sure in the room chat. I'm not really sure what the commentators is saying. Any other questions? Hi, Hero. Welcome to the stage.
Hey, Sam. Sorry I'm late.
No, that's fine. So basically, whatever information you have in your company, you treat it as a trade secret. You treat it as though this were a trade secret, because you don't want to make an improper determination at the outset. If you treat everything as a trade secret, then you know that all your information was subject to reasonable efforts to maintain their secrecy. And now the question is, well, did you derive independent economic value from this or not? And then we can sit down and debate that. If you're not deriving independent economic value, what the hell are you doing suing people, right? Because your damages are going to be zero. So it kind of filters itself out. And so we basically come down to reasonable efforts. And so you should determine what those reasonable efforts are for the particular industry you're in. Different industries use different standards depending on the type of information they're dealing with. And then assume trade secrets for everything, and you're going to be safe. So, was your question?
Hi, Sam. I think I unmuted for a while when I didn't have anything to ask, but I do have
Oh,
something that I do have something I wanted to ask if it's appropriate.
yeah.
About halfway through your seminar, you mentioned a presumption of property rights, and
No, 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 no,
oh
no.
oh okay.
Presumption of harm for the violation of property rights.
Fair enough. The presumption of harm for the violation of property rights. And if this question
Right.
is not on topic, just say, Steve, it's not on topic. I have noticed that when it comes to squatters, it appears the exact opposite. That the courts have been leaning more towards squatters' rights than any presumption of harm to the property owner. Did you want to comment on that, or is that not germane to this subject?
It is and it isn't, both. So, squatters' rights traditionally are dealt with adverse possession laws, which are common law principles. You know, they show up in the restatement of property adverse possessions. And it used to be the case that to adversely possess a land under original common law, it had to be 19 years and a day, that you had to openly and notoriously and whateverly occupy the land, adversely possess it. Openly,
I'm not
notoriously,
talking
and
about a squatter
as
getting possession of the land. I'm talking about a squatter being able to stay on the land.
yeah. So so yeah. So that is a part of adverse possession jurisprudence, and so that is now covered mainly by statute. And what happens is that the courts want to see property be used uh, for economic purposes. So if there is a dead piece of property on the one side and a piece of property that's working and is productive, the court is willing to nudge a little bit on the ownership right of the owner who left this be, and allow the person who's using it for economic improvement to continue the use. So basically, the courts are there to make sure that the economy is humming along. In other words,
Thank you. Thank you,
so
Sam.
yeah, sure.
Yeah, how
Hello,
you
Joseph.
doing? How's it going? So thank you for hosting this type of subject. Um, Sometimes I come in your
You're
rooms.
welcome.
They're really nice to see, just a different vibe on Clubhouse. But so I've since going to college, I became a researcher. NSF paid for half of my schooling, thank God. And I've been working with a industry partner, collaborator, and I have not created an NDA or signed any type of non-disclosure with anyone. And I've kind of stepped out with Brookhaven. I'm talking to folks. I've got material at University of West Indies, even the Israeli Institute of Tech in China. I have material on the way, and some of the information about the doping of my material is out there, and that's kind of like my recipe. But I'm still in this phase of telling my story properly so that I can get published and eventually get towards funding to start developing pilot location and maybe manufacturing one day, right? And I haven't really traveled down the lane of IP, and now I'm kind of worried because we're seeing results that matter. And I'm saying, like, for example, we went after solid state electrolyte, and my material enhanced the capacitance of the composite by magnitude. I mean, let's just say everybody got quiet after this happened, right? Because they're like, wow, the capacitance went from like 30 microfarads or 3 microfarads to like 20 some odd microfarad. It's just a huge improvement because of my material integration. And now I'm asking questions about what's next, and they've been quiet with me, and now I'm kind of worried. But I've got a track record with these guys, emailing them back and forth for well over a year, working with them, communicating, but we don't have any documentation. Now, say they go out and because they have a little bit and maybe enough to go out and get their own carbon and do their thing with it, and now they've got this capacitor that's doing great and they're making money off of it. Could I possibly sue them based on our relationship, or am I screwed and I need to get my legal business together?
And Sam, before you answer that, I wanted to throw in one word because I think it's appropriate for what the gentleman just said. Quantum Merowit. Go ahead, Sam.
Yes, that does
And
that
Sam,
mean
nobody
that?
knows why you're laughing except me. So go for it, babe. Go for
No,
it, baby.
does quantum merit come up a lot in employment law?
No, and the reason
Okay.
is because if you're an employee, you arguably your employer knows what you're
Yes.
doing. But however, if you're building a project on your own and then you're arguably doing it for someone else, then the answer is no, Sam. It doesn't come up.
Okay. All right. Yeah, that's what I laughed. I'm like, whoa, wait a minute. Why is an employment lawyer talking about quantum merit? But all right.
Come on, Sam. Be real. You were saying, "Oh fuck, Steve knows what quantum Merowit is." Amazing.
For those of you who it's a Latin phrase. The English version of it is unjust enrichment. So basically, if I do something that unjustly enriches you, then the court assumes that there is a contract between us and I need to get paid for the amount that you were enriched. So that's quantum merit. But anyway, uh, moving right along to Joseph's answer. Joseph, you have given me enough facts for me to say I need to know a lot more facts. And you have given me enough facts for me to say you need to talk to a lawyer. Go talk to an IP lawyer not necessarily a litigator, but an IP transaction lawyer, just any patent lawyer that that's worth his salt or her salt will suffice, because the questions that you're asking, they're not complicated questions, but they require the knowledge of pretty detailed facts to be able to determine where you are. Because based on what you said, I can. You first of all, you probably said less than one hundredth of the facts that I would need to say something. But based on what you said, it can go both ways. That is, your actions uh, could have basically foreclosed any future IP right for you, or they can be considered to very strongly establish your IP rights. It all has to do with what's in those emails, what kind of conversations did you have, how did you transfer this stuff, who were they, did the lab, did the attorney at the university at Brookhaven or West Indies, they was there a material transfer agreement between you guys? Who else was working with you? Who else had the right or could have had the right to sign off on this MTA? There are like so many things that uh, we have to know before I can tell you whether you have a cause of action or not. And so my best advice to you is as soon as you can, because this is a live issue, what you discussed, and so talk to an IP attorney and get their input.
Right. I was headed down that road, but in my mind, I figured it'd be more likely that I would patent my process versus the material. I mean, doping carbon is not novel, per se, but maybe how I've done it is. And they don't know
Yeah,
that, but they
again,
know,
that's something
you know.
that a patent attorney will be able to tell you.
Mhm.
After seeing all your data and all the prior art, and what is it that you did, what is it that other people did, and all that stuff, they can then tell you, can you go ahead and patent it or not.
Yeah, I guess too. My second question is about the NDA. Like, I feel like trying to get relationships in academia and with laboratories is very difficult for me, and I feel like they would take me a certain way if I come in and say, "Hey, sign this before I send this over." They're already difficult enough to get them to work with you, whether you're paying or not, and you know, I'm just wondering if that's even a thing for people at some point. When do you introduce that? Is it just for employees, or when you're working with collaborators? Do you do that? Is that common
Oh yeah,
practice?
yeah, absolutely. So uh, if you are talking directly with the PI, you're not going to get anywhere, because PIs are notoriously anti-IP, because they are notoriously pro-publication, and IP policies prevent them from publishing. So if you are putting a document in front of the PI, which is going to limit their ability to publish the results, they're going to balk at that. That has been my. I represented the UCI, University of California, Irvine, for years and years in a couple of projects, and so this is generally not just at UCI, but most universities, most PIs are like that. What you need to do is figure out who does the tech transfer stuff at the university you're dealing with. They have different names. Technology Transfer Office is the most common name at the universities, but they have other stuff, and call them up and say you're dealing with this PI and you're trying to get the agreements all sorted out, and they have basically one licensing officer or the PI is assigned to one licensing officer. All PIs are, even though they don't know it. So that licensing officer will then come in and mediate between you and the PI on the legal stuff. Then you guys can go on and do the scientific stuff.
Okay, cool. Thank you.
Sure.
Yeah, I would say the key to getting those kind of projects off the ground is, at least in our history, the lab director is the one who holds all the keys because he's probably done these kind of. They sometimes call them commercialization agreements or participation agreements, and they end up doing those with their students that they do startups with. They tend to deal with the Office of Commercialization or the other such office equivalent, and it is like, just to give you some numbers, they can ask anywhere from like 5% to 30%. So expect that it might be that high of a cost for you in terms of equity or that sort of thing. And if you're not doing that, then they expect to get paid, in which case the lab time is something like on average $1,000 an hour. So that's been some numbers that I came across in our work.
So I mean, the question is, what is it that you're giving them? I mean, do you need to have a material transfer agreement, a joint research agreement, a joint development agreement? There are a whole bunch of different agreements, and it all has to do with what it is that you're doing with the PI, right? And so somebody who understands the legal process at that institution needs to be involved to make sure that before this research really begins, all the legal paperwork is in place. And so, yeah, commercialization office, tech transfer office. In Utah, it's called Pivot, PIVOT. It's an acronym for something. I have no idea what. Yeah, you need to talk to the people at the university and not the PI. The PI will blow you off on legal stuff.
Sad to say, but true for me is my university has been lackluster across the board. I can't get a professor to support me really. They say it in my face, but they don't provide any real resource.
Where are
And
you at?
I just graduated from Old Dominion,
Uh-huh.
cum laude, and
Yeah, yeah.
I'm developing my own material, and it's sad because it seems like nobody will touch me with a 50-foot stick. It's some for whatever reason, they just don't want to. They don't want to
Yeah,
be a part of what I got going
so
on.
Old Dominion is not a major research university, and so it may not have these offices that we're talking about.
They have an office. They have one downtown, and they have connections with the Navy, and they have all of
So
the.
they had a tech
They
transfer office at Old
Yes,
Dominion?
yes,
Okay, okay, okay.
patent lawyers
Then,
too,
oh, all right, then,
they
yeah.
also have the analysis equipment that I need. It's a bigger issue. Clearly, I'm just
Yeah,
exposing
just,
it.
you know, call up, figure out who the officer responsible for this PI is, and get an appointment, go in there and say, this is what I'm trying to get this PI to do. What are my options? And they'll help you because they want uh, outsiders to be interested in their technologies. They will help you out. As guarded the PI is, just as opposite open the tech transfer offices. Any other questions, comments?
Yeah, I'll say this, that maybe Sam, you can comment on this. In the age of something like China doesn't care about our IP laws. Sometimes it's better to do a trade secret or even just hold off on publishing. What do you think about alternative strategies like that, or maybe something else altogether?
Well, whether you want to keep something as a trade secret or as a patent depends on how reverse engineerable that thing is. There are two famous examples of trade secrets. One is the Coca-Cola formula, that in the late 1800s and the 1890s, there was a debate within the company whether they should patent the formula or not. And the company decides to not patent it. And the formula is known by something like 4 or 5 people only. And so that worked for them because it is extremely difficult, in fact, impossible, to using current chemical analysis techniques to figure out what's in Coca-Cola and how much. So that's one of them. The other one is WD-40. WD-40 is a mixture of multiple oils, and the company's in San Diego, and they have contractors making portions of this oil, and it gets shipped under different labels so that two contractors may be making the same oil, but it's called different things, so they don't know that they're making the same one. And it comes in, and the company itself knows what percent of what oil gets mixed into the final formula of WD-40. So that is not patented, and because these oils are chemically similar, then again, it is downright impossible to do that. So when you're faced with the question of how do I protect my idea, do I go trade secret or do I go patent? You have to ask that question, that is it reverse engineerable? If it's that, if the information becomes readily ascertainable, if I just open the thing up or shoot it into an HPLC or whatever, figure out what's in it, then no, trade secret is not enough. You have to go the patent way. But if you can very easily protect the secret, like Coke or WD-40 do, then trade secret is much, much better than a patent. It's very fact specific. But the thing is that everything that you have, as I said initially, is a trade secret. So if you don't do anything, you're protecting it as a trade secret. I mean, not anything meaning that it has to be under lock and key, but you're not filing anything, you're not paying any lawyers anything, then you have a trade secret, and then you can then figure out, what do I want to do with this? Is it commercially valuable or not, right? A lot of times you wait to file a patent application because you don't know if the final product of this path that you're going is going to lead to a commercially viable product or not. And so you keep it as a trade secret until you make that determination. So that was a very long answer to your question. The short answer is initially keep everything as a trade secret. Then once the development becomes serious, determine whether it's reverse engineerable or not. And based on that, you can determine whether you want to patent it or continue keeping it as a trade secret.
Yeah, I'll just add a little bit more context. Like our technology involves both hardware components, so there's like a hardware development, and then there's like software and algorithms development. The hardware, we're wanting to open it up so others can use it, but we don't want to be stopped ourselves. So the only reason we see patenting the technology or the aspects of it is so others can join in and contribute and participate, and we're just going to make the patent quote unquote open source or so like freely available for anyone to use. And the only way that we see the value of the patent itself is something like it stops anyone from stopping us progressing this technology or working with it and so on. So that's kind
So
of
wait a
a
minute.
good
So you have two technologies, a hardware and a software. Now these need to be protected separately and differently. So on the hardware, do you want the hardware to be open for everyone to copy, or you want the
Yeah,
software
like
to?
Tesla did. They patented some stuff, but then they made it
Yeah,
open source so anyone can use it, and they don't
right.
really ask for royalties or anything. They just wanted the movement of EV like vehicles needed to happen. One of those things to do that is to convince other people to join the race, and so you
Yeah.
can
So
do
in
that sort of.
the 80s, Mercedes-Benz did that with their safety patents. All the patents on anti-brake systems, on airbags, on this and that, they basically put them all up in one database and said it's open to everyone, precisely because they wanted to raise the safety standards in the auto industry, and they said we shouldn't be making money off of that, which itself was a huge uh, commercial boom for them. But
Yeah, that sounds
so
like a great network effect. I'll have to keep
yeah,
that in mind. I didn't know that example, so thanks.
yeah, it is. So yeah, I mean, so normally in these situations, people patent the hardware, keep the software as a trade secret. That is kind of
Yeah,
the
precisely,
normal way to
precisely what we're
go.
doing. Yeah,
Yeah.
exactly.
And so if you want to, open it up, why are you then going through the cost of patenting it? Because once you open it up, it's in you have disclosed it publicly, so no one else can patent it. So, put all the design specs, everything up on your website and say, here it is, guys, take it. And 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 no one else can then patent it because it's publicly disclosed.
Yeah, there's too many controversies with that. So, like, one thing that we thought of is, hey, we'll publish in a few places and so on, and that kind of like establishes the precedent. So, I think it's an interesting challenge because to be sued by a patent troll when you're just trying to do stuff, if you don't have that patent portfolio, the courts look on that as a little bit less than favorable. You have to have your foot in the water somehow. It seems they require. You know,
I'm not sure that's true.
because I can't think of any examples of what you're describing. That was originally my approach, and literally the most recent round with VCs and stuff, they were like, "You want 50 million? Well, we're going to put aside 10 million for the lawyers so they can armor the shit out of this." And I was like, "But why? We can just publish it all." And they were like, "No, that's not how it works because somebody else will patent it, and then they'll stop you." And that'll create so much legal friction that you won't even get the next round of funding. So it's like a weird kind of like, hey, people don't play ball fairly.
As a great man that I knew once said, fair is a place where a pig goes to get a ribbon. Fair has nothing to do with this. Yeah, so uh, that's a specific situation you're describing, both in terms of probably the technology you're dealing with and the VCs you're dealing with. And
Well, I got that
so,
advice in a biotech charity dinner at IBM headquarters, and that was one of the IBM scientists who told me not to say anything to the engineers because hustle and flow, these big corporations don't play fair. They'll spin up an engineering team and beat you to the patent office. They'll beat you in publications, and it'll look like you stole their idea by the time they're done. And I was like, damn, that's fucked up.
so
I'm like, I'm so
yeah, I
glad there was
mean,
wine here,
see,
so everybody told me these messed up stories.
I see. I don't know where you are in this process, but in my field, uh, if my company is going to talk to Pfizer, I am absolutely sure that everything they want to talk about and everything else surrounding it is filed in a provisional application at least before they go to talk to them. NDAs, so we're not we'll be talking about NDAs next week, but or maybe the week after that. But let me just say that the only thing that an NDA does, a non-disclosure agreement does, is that it expands the zone of confidentiality so that the information that's disclosed under the NDA is not considered public disclosure under patent law. That is the only reason you sign an NDA. Why? If your secret's out, your secret's out. It doesn't matter if somebody violated some agreement. You can never recoup that secret. You can never recoup the harm that was done to you. So, so if you're relying on an NDA to protect your secret, then some lawyers say you deserve to have that secret stolen because
Yeah, see,
they
that's why I
did.
want to be open. I've only gotten progress because I've talked to people about it and we've shared ideas. Even here on Clubhouse, I've talked to you, Sam. You've been helpful. And just little details. I bring up the problem kind of obscurely. You mentioned some method, and there's progress. And that is like why AI is progressing so fast. Because
Yep.
if academics really go full open, like I'm lucky because we own most of the company, even after some rounds of funding. And it's like, okay, you get to command the ship. Not everybody gets to command the ship, so that takes a certain kind of negotiation. But when you have a really exciting technology, most of the doctors, especially like my family doctor, my lifetime family doctor, and my cancer doctor, they were like, hey, make sure this technology belongs to the world. And I was like, okay, I got you. I think that actually matters. And it really
Uh,
changed the way that I look at it.
yeah. But unfortunately, if the technology belongs to the world, then nobody's going to put up the funds to develop it, make it better, commercialize
Unless
it,
they're
distribute
activist
it.
investors. Activist investors do, though.
But
That's the cool thing about wealthy people who have
so
money who are
who
like,
donate,
I want to
they
do
don't
something active.
invest, they donate. You need, yeah, okay, so because now you're in the realm of nonprofit that runs on charitable donations. Because if somebody is giving you money to develop this technology and you're giving that away, there is no ROI here. So that's a
Yeah,
donation.
there still might be because you can still make a profit having
But
that kind of model.
that's
It's
really
really strange.
tenuous. That's really tenuous. Right?
It,
If you
it is
don't have
tenuous, but it feels
IP,
better.
yeah, so that's why you need donors and not investors, because donors give up money to feel better, investors give up money for the ROI.
Yeah, yeah. So like I had never come across this term like like activist investor. And so I started like Googling that, searching it up. And there's like entire VC firms that are just like about disruptive technology.
Yeah,
And
yeah,
even if it's like a very long shot, they still give you a shot. They give you like,
yeah.
the
But they're
effects
like
now with AI, you can.
0.01% of the VC money that's out there. So your competition's really stiff. Richard, I sent you an invite if you want to come up.
Well, I don't know. I've been in that fight competitively for a while now, and yeah, it's a strict competition. But if you're working on something that has a mission and you have a good team, I think you have a chance of especially making
So
it. So I
yeah,
don't
so
think it's
then
0.01%. I would say it's like a 1% moonshot,
no,
but that's what it is.
then you need to register your company as a B Corp and get into that ecosystem, right? Because once you register as a B Corp, then you now have access to all the B Corp people, all the B Corp investors, all the B Corp CEOs, all the, so uh, look into that because really you're what you're telling me is that you're not a not-for-profit, but you're a public benefit company. That's what you're telling me. So you're a B Corp and registered as one, and then you get access to everything. Hi, Richard.
Hey, Sam. I have a quick question. It's kind of on I heard the subject of AI coming up, and it's one of my hot buttons. Um, Even though I'm in the finance world, my background you might be able to relate to. It's strongly aligned with big pharma and medicine and healthcare trends and technology. I try to work out on the front of the skis of the industry because I started out that way as just out of college. I worked for Norman Shumway at Stanford, who did the first heart transplant, if you recall the name, in the United States. And so I tend to be somebody who's some would say you're a dreamer. Some would say you're anticipating. I actually call myself a futurist with a scientific bent, a realistic bent, and I have an idea in the works. It actually started to form about 2 years ago with some of the preeminent scientists on Earth who are working on de-aging human beings. If you're familiar with the technology, some some scientists at Harvard have de-aged mice from old age to middle age. And you can say, well, what does that mean? That doesn't mean anything for humans. Mice aren't humans. But in point of fact, mice are mammals. And once you've de-aged a mammal, you are heading towards human de-aging. And that's something that's in the buzz in the research world for the studying of aging and whatnot. One scientist at Oxford University, his name is Aubrey de Grey, or has predicted that the first 500-year-old person may have already been born. Now, leaving that, it's kind of a controversial subject. I am interested in how AI will resonate with that, how it will be. Um, I'm interested in investing and putting efforts into that project because the coordination of all the scientists who are working on it and all the information that's available in it, all the books that have been written on it, and all of the serious scientific endeavors that are working on it is going to be quite a project. And there needs to be probably an AI source that's going to help coordinate it. That's my opinion, and that's what I wanted to suggest today. I like your show. I like this conversation. It's extremely edifying, and I appreciate it.
Well, thank you very much, and thanks for the comment. Uh, I'm really curious to see where this AI thing is going and how it's going to get used. Uh, but I know for a fact that I'm not going to be here when it finally hits the market, like the way internet has. Uh,
I
I'm
think
too
there's
old
enough
for
data to
that.
clone you. If there was enough data to clone you, Clubhouse, we'll make a clone of Sam, no problem.
You know, if that technology existed, I would not opt for it. You know, one time around was enough for the glow.
No, no, but it's got to
I
be
don't.
forever. It's a new kind of hell.
I'm not gonna impose this thing on the world again. Just once was enough. Yeah, James. He writes in the chat. Any comments on Schmidt's Stanford talk that encourage copying first to be successful first, and finding the lawyers to cover your ass with
That's
IP
exactly what I was referring
lawsuits?
to. Yeah, yeah, exactly the advice that I got. And literally,
Yeah,
you'll find the lawyers later to fix the problem. Just make sure it works.
yeah, that's highly unethical. And so I
That's why
personally would,
Stanford took down the talk, actually.
yeah,
They took down Eric's talk that said
I
that.
would not, I would not recommend a client to do this because, you know, uh, I'm a great believer in following the system because the system actually the way it is set up is pretty efficient. And if you start doing that, you introduce unpredictable inefficiencies into the system, which because they're unpredictable, I don't know what they're going to do. So as someone who, you know, lawyers have to be conservative, right? They have to reduce risk and liability for their clients. That advice multiplies risks and liabilities for the client multiple times because you don't know if the lawyers can clean it up afterwards. You may have fucked it up so badly that lawyers can't clean it up. We're not gods, right? I had a partner who had a sign in his office that said 70% of my job is to clean up the fan. And that's true. We get called in when the shit hits the fan for us to clean it up. But there are times that we have to say, you know what, client? This is the shit you have to eat. Sorry.
Jesus, you could have just said, no, this is the shit that we can't clean off. The fan is doomed. You got to get a new fan. No, no. In Sam's world, you got to eat that shit.
Well, guess when who's standing there with the mouth open when it hits the fan? It's the client who threw the shit.
Oh,
So,
geez, even more graphic.
yeah. Yeah, I don't like to ever advise a client to engage in an illegal act. And I bet you that advice doesn't come from a lawyer, it comes from a business person. And this is why CEOs and chief legal officers are always at each other's throats because the CEO comes from the Wild West and the lawyer is Poirot. And those two kind of don't mesh. Okay, We're coming up on 2 hours. Uh, I'm kind of getting tired of talking, so we can either just completely open it up, change the title, and have a kind of a popcorn style conversation about anything and everything. We can
Maybe
close this room
close it.
down.
Yeah, close it
Yeah,
down and open another one so that other people, when they're listening to the replay, it'll be self-contained.
okay, sounds good. All right, guys, I'm gonna close this, and then in scientific discourse, I'm going to open up a room called IP Law After Party. So hope to see you guys then. The room's gonna close in 5,